We'll carry on with the introduction of the panel.
Tasación de daños y perjuicios en materia de derecho de autor y derechos conexos. Carlos Andrés Corredor, Dirección Nacional de Derecho de Autor, Colombia. Hugo Gómez, Tribunal de Justicia de la Comunidad Andina, Perú. Mauricio Jalife, Jalife Caballero, México. Moderadora, Jacqueline Moreau, González y Asociados.
Hello and good morning. I'd like to thank the Executive Committee for the invitation to moderate this panel, which is an amazing one. I'm honored to be here with my guests and panelists today. Throughout the next few minutes, and in the interest of time, we'll talk about the emerging damage and moral damage seen from your perspectives, your interpretation, and how the Andean Justice Tribunal is addressing this, and Colombian authors' rights authorities, as well as Mexico on laws of industrial property. We'll be sharing cases, very interesting cases. Each of you will make a presentation, then we'll have a short debate among panelists, and finally we'll have a few minutes for questions, just that we won't have awards for your questions in this case. We have Hugo Gómez of the Andean community, professor of the master's program on authors' rights and competition from Catholic University of Peru and from the University of the Pacific and the Faculty of Jurisprudence of the Universidad Católica de Ecuador. Welcome, Doctor.
Como pasó. Muy buenos días a todos. Muchas gracias.
Good morning, everyone, and thank you to ASIPI for the invitation. I'd like to greet Mauricio, Carlos, and Jacqueline. Now, we have focused on this subject and decided that I would address the conceptual part of the indemnizations of damages due to property, intellectual property reasons. These are the topics that I'll be addressing in these next few minutes. The moral damages and independence of these damages, and regarding the pre-established indemnizations, which we'll have a debate on with Carlos and Mauricio. Now, a general principle is those that we're obligated to compensate. But there is no obligation for the right to cover a device like we see in Article 57 through 51 for it to be applicable. This is to say, it's not necessary for legislation for the positive right or the treaty to have to say that the victim, the titular of the author's right or attached rights, will receive an indemnization for the damages caused by infraction. It's not necessary. Even if the law was silent in all aspects, the owner of the right has the right to request an indemnization for damages. It's just a general standard. This is something that we have to keep into mind as a general standard. You're seeing Article 57 of the Andean law, And so what this does is it basically confirms this general standard, and so among others we can order the payment of the adequate compensation for the damages as a consequence of the violation of rights. Although the general principle is talking about guilt, or in a sense, this is modulated depending on every guideline in the Andean tribunal. It's been explained that infractions to authors' rights are channeled through objective channels. This is relevant. Guilt can be an aggravant, or intention can be aggravant or not. In principle, the burden of proof lies on the victim, and in terms of authors' rights, the obligation or the responsibility can be contractual or extra-contractual. And so these kinds of infractions can be for violation of contract and as the acts of piracy or not. We apply the principle of causality between the infraction and the damage. Must recognize that there can be a fracture of the causal attachment. This would remove responsibility from the presumptive infractor. Regarding this article, the Justice Tribunal has highlighted that the reparation is integral, which is applicable in all of these cases, and it's not necessary to say. And so this means that if the legislation just said emergent damage, doesn't mean that there cannot be reparation of moral damages. It must be. If it did only say that, this doesn't mean that there can't be. The rule is that all damage must be repaired, even if the law doesn't say it. It is a general principle: all damage must be repaired. This integral reparation includes the payment of costs, representation fees, administrative fees, anything pertinent. Let's go to the emergent damage. This is what arises from the patrimony of the victim. It was in their patrimony and it is removed. That is the emergent damage. It is the loss or detriment of the right owner, victim of an infraction. And we have some criteria here that can serve for the calculation of the damage. The status, trajectory, or reputation of the author. The more prestigious, the higher the values, the market value, the original. Investigation fees are part of the emergent damage. And I'll give some examples there. The destruction of a painting, for example. The painting is destroyed, and that is part of the patrimony of the owner. It has to be repaired. But it can also have to do with the motivations. One brushstroke can be enough to completely change a painting. It's no longer the original. It's almost like setting it on fire. So with regards to the destruction or the theft, the emergent damage is relevant. And so again, there's a devaluation of a piece of work. To talk about imminent damage, we don't have to talk about total loss. It can be partial. Reduction of value is an emergent damage. This next one is what should have entered the patrimony but did not. If the infraction had not occurred, it would have entered the patrimony of the victim, but because of the infraction, there was no there. So if the infraction had not taken place again, they would have received that income in some cases. And if the unit sold by the infractor could have been sold by the right owner, the royalties, if a license had been assigned, and for that license they're receiving royalties, then that amount can serve as a point of reference for that to be paid. But if something like that has not happened, we might think of a hypothetical organization and reasonable royalties in the case of a hypothetical negotiation. And so Article 57 of Ley 44 of 1953 in Colombia speaks of the value of those contents produced or reproduced, or the value that would have been received if there had been authorization. Remember, we talk about revenue, not benefits, not utility. It's the revenue itself. In this calculation, it's always the revenue. Therefore, if I'm thinking about the commercial value of what is sold, that's a brute revenue. It's not utility or royalty. It's an error to think about the profit or the utility. Imagine if the author doesn't know how to manage their business, but not just breaking the law, but they're incompetent, and they may actually be showing losses. And so if I have losses now, I have nothing to compensate, or for them to get robbed. But if it said, yes, I did violate a law, but I was robbed, and so I have no revenue, and so I have nothing to compensate. No, that's an error, because what gets quantified is the revenue itself, brute, total. It's not like I deduce the taxes and my expenses. No, it's total revenue. And the typical example always in processing is a piracy. Not all of the units sold illicitly. Pirated music, moral damage. We indemnize the suffering, their damage, the effect on their honor and reputation. This is the more discretional part of this, the less objective part, and we have to respect that it's subjective. It's difficult here to expect a mathematical response that won't happen. There's criteria established by Article 140 of the Spanish intellectual property law, the circumstances of the infraction, the gravity of the activity. There are different criteria to this. There can be others. We always calculate an economic value. It's true that the pain, the anxiety, depression are sometimes difficult to quantify, but reparation is economic, and so a judge has to assign a value. It might say $10,000, $20,000, $30,000. It doesn't make sense to tell the judge that they can't prove the value of it. Here there's more discretionality, and that discretionality must be respected. The judge might have the criteria that if you've gone through depression, if I were to go into depression, how much would I spend on psychologists and psychiatrists? And could we look at that? That could be the case if we wanted to be more accurate in quantifying these things. Some effects, the sharing of the work without authorization. Let's say there's one where you think it's not at the level of others, and so they speak to editors and say, don't publish that, and it doesn't get published. And in effect, it is a bad book. The critics are speaking. He asked for it to not be published, but it was published, and it affects them. And now here we have to compensate their damages. An example authorized by my friend Natalia Tobon was writing a book with Eduardo Varela, a very controversial book, the right to adult entertainment. So these are rights associated to pornography, and so there are doubts. The editor said, we don't know if we should publish this. We've posted some pictures there to be very clear, and this images are very strong. This is going to cause problems. Don't publish it. but the editor publishes the book. And then the critics speak up, and we realized, yes, our society isn't prepared for this. A lot of people have things to say, and now they are affected. Now we have to compensate for that moral damage. Plagiarism of the work can irritate the author, and so all of that damage must be compensated, independent of the damages. Because I read from an author who said that moral damage is only for moral rights, right? The infraction to patrimonial rights can have not just material damages, but moral damages. And the other way around. Some time ago, I gave an example, but I didn't mention it, of moral damage when the author sends a book to the editor, and the editor makes grammatical mistakes. Those errors will impact the reputation of the author. If I wrote things well, if it was well written, and then these people changed a comma, or that period should not have been there, or they cut a paragraph, now it's not well written, I don't like it. There is a moral damage there, but that can cause lower sales because of all of those errors, because of the critics and so moral damage and patrimonial damage. And in the case of piracy, there can be, of course, moral damage. The owner can feel irritated. They can even go into depression because of what's happening. And so they're independent damages. And concluding, I'm still on time, right? Yes, we wanted to talk about pre-established compensations, or which is that's the legislation that establishes minimum amounts. So there would be, again, these were received by pre-established indemnizations, allowing us to provide the right protection to the owners of rights, because it is difficult to prove emergent damage. And by establishing specific amounts with certain rates, this makes it possible for the judges to see other criteria, and so that the victim isn't spending resources on investigating and searching for that emergent damage. What criteria could the judge take to calculate the duration of the infraction, the value of the original products, if there has been intentionality or not, if the lives or health of people were put in danger or not, the incidents, if there was intention to profit.
So these are elements that are easier to value in terms of the judge, and something important to take into account is that I also criticize those authors that say that this should be the last instance that they try by themselves to prove their loss of profit. And if they cannot prove it, then they go to other stages. It shouldn't be like that. The holder of the right should choose what's more convenient. If they have any kind of evidences in terms of the loss of property or profit or anything, they should follow that path, or else they have to choose the pre-established indemnification. This reduces the cost to search information on behalf of the holder, and it reduces costs on behalf of the authorities and the judges. This will, of course, reduce costs for society, and we must think in this. The idea of the pre-established interventions is to favor the path of the victim, not the infractor. There is an error where some think that you have to facilitate things to the people that are committing the infringement. No, we have to facilitate the path. It's for the victim. And I want to finish with this. This is a prejudicial sentence of the Inter-Andean Court that has to do with the pre-established indemnizations that are consigned within the Colombian legislation in terms of brandings, in terms of trademark. Nonetheless, what is said there is also applicable for copyright. So please follow me with the reasoning that the tribunal made, because amongst the questions, if the established indemnization is followed or not correspondency with the Andean right, the Tribunal of Justice of the Andean community said yes, the pre-established indemnizations do not violate the Andean right. On the contrary, they make part of the criteria that can be used for an adequate reparation. And the tribunal also said that in the measure that the informality translated into the unfulfillment complete or partial of the legislation is something that is going through the members of the communion of the Andean community, we cannot unacknowledge that despite that the infringement exists, sometimes it's complex for the holder to demonstrate the damage that he has suffered. I think that the infractor does not have undue authorization on behalf or in front of the authorities. They sell in the streets. They don't have invoices. They don't have sales registrations or records. They don't have any kind of records. They don't declare or pay taxes, where it will be very difficult to know how many units they sold or how many products object of the infringement were sold. So it would be quite complex to be able to demonstrate the loss of profit. Therefore, for the Andean community, tries to use this path to the protected indemnification to be able to protect the holders and the connected rights. Thank you, doctor. Let's go to the next presentation. Carlos Andrés Corredor. He's an attorney specialist in commercial rights, professor in economical rights. Labor in his work, he works as subdirector of jurisdictional topics of the National Direction of Copyrights in Colombia, an entity that where he's always been the head of the Office of Registrations and in charge director as well. So, thank you very much to all of you. Thank you very much, ASIPI, for the invitation. It's a pleasure for me to share with the people that are currently with me in the panel, with Jacqueline, Mauricio, and Hugo. This is one of those topics that I believe are quite interesting and around the topic of copyrights, and it's also polemic. And it it's polemical because we have not had the people that are dedicated to the topic of responsibility from Joserani, Planion, and that jargon must be also carried on behalf of intellectual property. Nonetheless, we will try to give you some point of views and some experiences that we've had in the National Director of Copyrights in terms of jurisdictional topics that we have or issues that we have, because sometimes we play as judges in conflicts of copyrights. Therefore, the first discussion that I believe must be taken into account is that we're starting from the point of view that there is an infringement, but after the infringement, what happens? How do we prepare? How do we compensate the damages? And one of the first discussions that we can hold is the infringement by itself a damage, or are we going to be repairing the negative consequences that come from that infringement? That's a political decision that must be taken on behalf of the different countries, be it through its judges or through its legislation. Obviously and certainly what we have seen in Colombia are certain small points of view, like trying to separate the concept of damage from the concept of the damage received. So, and damages are the consequences of this phenom, but moreover than this distinguishment that is different specialists in the topic of treatment of damages, the important point is to know what are we going to be repairing. The damage or the consequences. So in Latin America, we usually try to repair consequences. And these have implications in the topic of copyrights. Now, going around the topic of the negative economical consequences, but before going into this topic, why did I mention this previous topic? Because if we're going to be repairing the right, we, different to the people that have a northern juridical perspective, sometimes we try to make an in nature reparation. And in topics of copyright, that's plausible, and it's possible in certain occasions, or in many occasions. For example, if we make the reproduction of 500 samples and it could not be done because they didn't have the authorization, in that case, the natural compensation will have to do through the preliminary injunction. We must ask or try to start looking how to make the compensation through the person that made the damage. We're still not talking about money, but as there's a correlative obligation, what's the obligation that the person has in terms of the rights of reproduction to not reproduce anymore? This obligation of not doing, as soon as you execute it or do it, it generates an obligation of doing. Destroy what you shouldn't have done. And this destruction can be quantified in money within the framework of a judicial process or a legal process, precisely because the orders would be directed towards that order. So let's also think that this could be applicable in moral rights. Let's think on the right of paternity, which is a correlative relationship in terms of paternity for the person that has a license to be able to use work, to print it or distribute it. In the case of an editor, well, to include the author within these samples, that's something that has to be done. That's an obligation. Therefore, how can we naturally start making a compensation to this right without going into moral thoughts or anything, which we must order to include it? How can we order this? So we say to 500,000 from those 1,000 samples, 800 were sold without the 200 were sold without the name. We can pick up the other 800 and we can order them to be dismantled if they're physical, which is a bit more complex. Include a sheet of paper with the credits, and additionally be able to afterwards sell it. And all of this can be valued in terms of money, precisely because there is something that must be done that has not been done before. When we go from this way of repairing in an innate form in situations where it's not possible, and I mentioned this because in copyrights, in many occasions we can go into these kind of compensation formulas. In this case, what we will find essentially two ways of compensating or reparating damages. The first one is to go into the traditional criteria. So we go in this case into the preliminary injunction, for example, and naturalizing these theories into the particularities of copyrights. And there will be other moments in which we will be able to go into a system that is known as the global summa global. We can use any of these systems, but it's necessary for the judgment to open the space for these two options. Now, in terms of loss of profit, I believe that previously they spoke very strongly about this topic, so I wouldn't like to repeat what has already been said, but what I want to mention about the loss of profit is that I personally consider that it's not the earnings of the infringer. Those would be the benefits. The loss of profit is effectively those earnings that the holder should have received due to the infringement, but he didn't receive them. Now, in many occasions, this could be simple to be able to be proved, like in the case of collective management. These are entities that traditionally and irregularly grant licenses, so that in the case of exclusive rights, they allow the usage in exchange of a compensation. So it's easy to think that all the people of that sector normally pay that money. And if there is someone from that sector that is not paying it, that's where we could find that loss of profit. And in terms of the quantification, we could use the comparable transactions, be able to look how those businesses have been doing with other similar people. That in this case would be compared with the infractor, and it wouldn't be the typical pirate or the typical counterfeiting person that work within the framework of a legal activity, and for some circumstance, or because they didn't know, for accountants situations, because they don't want, or due to policies, they say that they don't want to pay it and will politically just battle to not do it. All these kind of situations could happen within our countries. Therefore, we can receive these kind of events. And in these kind of situations, we can also go to the guide of ratings or rates. And the Andean court has also said that this is another reference that can be used in the case of emerging damage.
Tampoco para, digamos,
To not repeat what has already been mentioned, I would like to mention, I would like to talk about a special situation. The emerging damage could have repercussions within the author or the works. There could be damages on the name of the author, in the sense that you could associate this with the bad quality of an infringing product or good. And it could also be relevant when you make the calculation. For example, how much does a work cost? Well, the work costs what you expect the work to produce throughout its useful life or its life cycle. And you can make these estimations through expert studies. Nonetheless, current infractors could damage and change that logic of what could be produced towards the future in terms of work, and this you can make a calculation from. But in the experience that I've had in those, or we've had in those 500, 600 processes that we have worked on, well, we have never seen that it can be proved. And in the other case of the emerging damages, there are other costs that could be related to strategies or situations that are done by the party when they're in front of an offend. You can be working about over a musical work, and you realize that it goes before into the market, and you say, okay, let's anticipate this launch. This could have logistic costs. You could even say, let's press or go faster in the distribution. These could have overcosts, costs that that the holder of the right should not have, but that usually are not required or could be required as an emerging damage. And of course, all the costs that have to do with the process per se. An important point, in many countries, they consignate the possibility that through the costs, you could recover most of the money that are included within these elements. However, most of the legislations in Latin America allow that when the decisions are split, the judge can just stop trying to condemn in cosas. Now, whenever there's an infringement, even if all the infringements are not claimed, the ones that, or even if we don't get all the sentences that are requested, it is important for the judges to take into account that when there's an infringement, they should give the sentences on favor of the demander or the plaintiff, unless you have divided opinions when a person declares that he's the holder of the right. And in these kind of situations, you can declare that a person is an author but that the holder is another person. In those special cases, perhaps we could have those decisions in terms of costs in a separated way. Now, in terms of the earnings of the infractor or the offender, I believe that this is an interesting topic, because you should ask yourself, whenever you realize that the damages that are suffered on behalf of the holder of the right, and you've already calculated how much the offender was benefited on, and you realize that there's a difference, well, what happened with those earnings? What's going to happen with this? So we also need to take into account a political decision in terms of those profits. If the offender stays with the profits, or if they're given to the holder of the right, even if they're not a negative consequence that he had suffered. I personally believe that they should be given to the holder of the right. In this situation, what we have found around sentences around the world is that it influences if the infringement are one of those obscene kind of infractions, or if it's on the contrary, those kind of infractions that, well, are not so strong. The important case here is that if you give the offender the profits of your illicit or illegal activities, you're really generating an incentive to keep on creating this infraction or this infringement, despite the fact that the holder of the right did not suffer any kind of loss. And to close, I want to talk about a global sum in terms of what's known about the hypothetical royalty. You could understand this as a way of calculating that loss of profit, and what it really is a fiction. It's kind of a fiction that consists in building a licensing contract that doesn't exist. And based on this, you would need to calculate the value of the royalty that was received on behalf of the holder of the right if this had been celebrated. To perform this work, you must look at all the different circumstances that could have incited in an eventual negotiation. Debates around the situation. The first one is if there should be or not a request to do this. I personally believe there should be, because towards the end, the judge is creating a license contract, and if it is used without the part requiring it, you're really just denaturalizing the exclusive right. Why? Because for the offender, it would be simply efficient to infringe the right and then just simply wait for the judge to recreate the contract, and you would lose the concept of exclusivity that goes around most of those copyrights. So thank you very much, and with this I finish my presentation. Thank you very much, Carlos Andrés. My third speaker, Mauricio Jalife, is a doctor in rights for the Autonomous National University of Mexico, a specialist in intellectual property on behalf of the Pan American University, founder partner of Jalife Caballero, a firm that is directed to copyrights, trademark, franchises for more than 35 years. He's a referee for the MP, author of 7 books and more than 300 papers. Welcome, Mauricio. Thank you very much, Mauricio. Thank you very much, Jacqueline. It's a pleasure to be with Carlos and Mauricio. From these thoughts to prepare the panel, I must say that it's been very interesting to share these criteria and these point of views. And I have the role of talking about the Mexican experience around the topic of establishing a fixed rate of compensation. It's been an enriching experience. We have almost 30 years with this disposition that was born in the strict sense of those decisions that Mexico took in terms of incorporating themselves to international treaties of free trade at the beginning of the 90s. On one side, the Treaty of Free Trade with the United States and Canada in the year 1994, and afterwards what was anticipated by APTIC 1 year later. And finally, it lands in our internal right as a disposition that establishes this possibility. Until before this alternative of being able to go to a tribunal, to a court, and request the payment of a compensation based on a percentage of the sales of the offender or any other criteria, the truth is that our history of procedures within the country of judgments looking for compensations that would really compensate in the magnitude of the infringement, I must recognize that they were not enough, they were misguided, and in certain occasions we even went to the extreme of trying to change the mentality of our clients of following a procedure that would be able to achieve or attain a compensation. And frankly, I believe that we were at that time in a stage that was still incipient in terms of the understanding of the integral compensation, in terms of the type of damages that are generated in these infringements into intellectual property. And aside of this, it was quite complex from the processing point of view to be able to demonstrate the cause between the illicit action and finally the consequence, the damage, and be able to demonstrate that effectively the the infringement behavior was generating directly some damages, and based on these obstacles and that incapacity of the system to be able to create a remediation in these kind of actions through what we understand that would be like an alternative formula to be able to repair a damage. Sometimes we cannot repair it directly because we need to quantify it in money to be able to in some kind of way to be able to compensate the violation that was done. But when this disposition came along for the first time in a country, even if there was some kind of background in the previous copyright law, but when it was integrated into the law of industrial property in 1994 as an outcome of the treaties that were suggesting for it, to be honest, it was a novelty. Because in Mexico we had very few cases of what was understanding as a punitive damage. In the same exposition of this kind of a disposition, the legislator would manifest or would justify the presence of this kind of disposition, making a reference saying that in Mexico there was a long tradition. That's what the legislator said in topics of illegal damages. Damages that not only pretend to make a proportional compensation of the infringement that was committed, that try to look in a certain way to quantify or try to balance those damages with the purpose of compensating them, but they also look to punish the offender, which means to be able to give a precedent, dissuade the behaviors not only of that offender as it was, but all the market as well, imposing some sanctions, some economical sanctions that were plausible enough to be able to give an example. Following this style and the calling of the criminal rights of these ends to be able to justify the punishment and translating them into the copyright world. The truth is that the only background, even that they said that we had a big tradition in these kind of figures, this was really a figure that we had imported from the northern world and throughout the treaties. But the only background that we had was the sanction that was presented in the credit operations when someone releases a check without funds, and where the law establishes a specific rate of sanction of 20% in terms of the quantity that is related to the check as an objective of applying this as some kind of offend and trying to compensate to the destination or the receiver. But in that case, we didn't have in our legal system any kind of figure that is related to these kind of damages. Today, it has been generated in other matters, a certain interpretation that has allowed us to assimilate this figure. And this moment, or in this milestone that I mentioned, was important because intellectual property was receiving the recognition and the importance that it required in terms of being able to reach a real compensation when an infringement was being done. So the precept was only limited to say that the compensation of damages due to the violation of rights that are conferred by this law. In none of those cases the law mentioned that it would be inferior to 40% of the price of sale to the public of each one of the good or product or service prestation that implies the violation of one or several rights of industrial property that are related to this law, which means that with the free election of the holder of the right, he could select to embrace himself into this fixed rate of 40%, or if it was considered to be insufficient, they could migrate to request or be able to move towards a direct request, where of course in that case we did have to start demonstrating and giving proofs. This formula was read at the beginning. It was understood as the need to be able to understand the existence and the reason of the infringement, but also to understand the quantity that was being claimed. It would be enough to simply go into the books of the offender with the purpose of determining the sales, the time that the violation lasted, and be able to reach a determination of the payment that was the outcome of such quantification. This disposition, which I will be mentioning briefly later on, found a reflection in concrete cases that started to validate it, where we started to try to prove and use this compensational mechanism. Finally, in the year 2003, this same disposition, in a certain way, with the learnings that we had received throughout those 9 years, were reflected in the federal right of copyrights, assuming that it was a mechanism that in a certain way had, of course, given us some valuable outcomes, and it was translated in that law, and in this way the reparation of the material damage or moral damage, as well as the compensation due to damages and prejudices due to the rights that this law gave, and in no case it would be under the 40% of the price of the sale towards the public of the original good or the original prestation. And here we highlight this because it's a substantial difference in terms of the formula of industrial property of any kind of service that implies a violation to one or different rights that are entitled in this law, which means that the difference that was assumed is that here the quantification was not going to be done in terms of the products that were sold on behalf of the offender, like in the case of brands or patents, but in this case it would be done over the original goods or original products. And in this reason, the legislator exposed it under the premise that we cannot, in terms of copyrights, we cannot, well, thinking in pure piracy, we cannot quantify over the value of a CD, a compact disc, or a DVD that has an infamous price in the market, and that additional to this, they are normally covered economies, clandestine economies, that where we don't have any access to numbers, and there is no reason to be able to translate this formula to copyrights. Therefore, we must take as a reference value the value of the original product, the 40% of what the holder sells in terms of his own products. And I believe that this was a reasoning that is probably valid from the point of view of the concept, academical concept, but from the practice, it's had a series of issues to be able to put it in practice. And the other paragraph that this precept added in 2003 is that the judgment with the presence of experts would fix the import of the indemnization due to damages in the cases where it's not possible to determine conform at the previous paragraph, which means all those different cases where we cannot apply the formula that was proposed in the calculation of 40% over the sale of the original goods of the holder. In that case, we could go into the original formula, looking at the damages, using experts that make a quantification, and of course give the judge elements of conviction to be able to take or calculate that damage. And so what cases have we had in Mexico that have given a milestone or a reference, or that have established certain principles around this topic? The first one, the most important one, was the Sebring case, which was the case of car manufacturer. Well, not car manufacturer. It's the manufacturer of adaptation stores car in Mexico that registered this brand inspired in a race circuit in Florida. Years later, the company Chrysler developed a model that was important to Mexico first, and then they decided to manufacture in Mexico and export it into different countries around the world using this brand. When they realized about this, the different parts had a certain commercial linkage. They talked with the holder of the brand. They explained the need of translating this brand in exchange of a reasonable fee. They don't agree, and aside of this, the owner or the holder of the Sebring brand, to make a bit more intensive this conflict, he was an attorney. He was a civil attorney that was very well recognized, that creates a full strategy to demand Chrysler the payment of immense quantities. The law in Mexico establishes, like in many other countries, that the manufacturing in Mexico, even thought for exportation, is valid to be able to demonstrate the usage of the brand. And based on this consideration, what came out is that all the vehicles that were manufactured in Mexico under the brand of Sebring to be exported would go into the account or within the calculation.
This process took a couple of years. In this process, evidently, we included all of the values for exporting, and when the first numbers started to come up regarding the financial amount claimed by the patents, the amounts were amazing. It was just unstoppable. The situation was inexplicable, the numbers that were reached, which began to put us in the perspective of actually really valuing what kinds of considerations we were facing Finally, the parts reached an agreement, obviously of the payment of several $1 million, I think around $11 million, which was published in favor of the acting part, and that's what it was closed on, arising from a matter which during other times would have been absolutely impossible. In the case of McDonald's, we face a situation in which the company began to make use of a commercial advertisement or a phrase, which is the first burger with a Mexican flavor. And so the administrative authority confirms validity and the existence of the infraction, and the lawsuit for damages reached important amounts. And here the acting part had difficulties. It had been an infraction against McDonald's in general, but a franchisee who had been commercializing that product in particular. The account was limited to how many burgers of that type had been sold during the period, but it was still a significant amount, and that decision had to be exported to take it to other franchisees who might have incurred in the same infraction, which procedurally implied problems. This was resolved through the payment of an important indemnization. There's a case still in Mexico for iPhone, which is still in the same premise, registered by a company in Mexico before the Apple iPhone, and which is still in courts, but it follows this line of a rate or amounts that reach unimaginable numbers. In the part of authors' rights, the claims of models of all type, talent, which exceeds the amounts that have to do with the commercial announcements and campaigns, of which the most representative is the case of Johnny Walker, case processed in Mexico, confirmed by the court. There are still some procedural matters to resolve, but in principle it's a case where the whiskey company carries out a campaign called Walking with Giants, Caminando con Gigantes, where they use the image of Gael Garcia in certain announcements, as a formality of picking up a signature of, obtaining a signature of the actor. The campaign is launched, and then the authorization isn't confirmed. This leads to calculations where the judge considers that during the time that the campaign was in effect, certain sales were generated in favor of Johnny Walker, and Johnny Walker should pay 40% of those sales of the products, of the original products, in favor of the actor who had participated in the campaign, reaching again numbers that have nothing to do with the real values involved in the conflict. Currently in Mexico, there's an important case being deliberated. The famous singer of Mexican music, Vicente Fernandez, probably the most recognized, where his image is used, but the most important debate is whether the right to publicity is inherited or not. If making a docu-series of this nature, if it's viable or not from a freedom of speech perspective, or if there is an infraction. Here we still have the determination of whether there's an infraction, and then to proceed to request a compensation due to this circumstance. And in this case, due to attached rights, which I'll refer to because of the nature of the panel that we're in, it's determined that these aren't applicable or useful, that those fixed rates aren't useful for those collective associations to charge attached rights for audiovisual works in hotel rooms. But it's necessary to condemn or to sentence the payment of 40% of the revenue of the hotel for stays. And so this is mind-blowing when we see a declaration like this, thinking of what part of the composition of the price it has to do with the possibility of a client playing a movie on a screen in the establishment. But this result, obviously, from a very taxative application of the law, a very literal one, such a formal legal system such as the Mexican one, such a solemn one, where sometimes this type of deliberations aren't followed by the judicial authority, and which gives way to these kinds of determinations, in my opinion. And this, briefly, because we're running out of time, today the law of industrial property is beginning to change and impact gravity here in a fixed manner, leading to a set of indicators of legitimate value, which is what we call them in November of 2020, where we propose certain possibilities for the claim of damages based on different criteria, what Carlos was sharing. This is calculated at market value. But it can be the utilities that the owner stopped receiving due to this, due to the infraction. But it can also be the royalties that weren't paid by the infractor. This not based on the lawsuit. As it's invoked, since it's a more pertinent criteria for a proportional calculation of indemnization, what have we reached? And so this, honestly, is due to constant and ongoing extortion, where the sentences are brutal. This is to say, something is wrong when a client comes to see us happy that they're basically happy because they're going to tell us that they've detected a violation of their rights and that we can begin a case of this type. So my only reflection here is that, look, I don't know if it's a matter of the percentages being poorly calculated. I don't know if it's a matter of a lack of control in terms of the judicial powers and what tools we have to leverage for us to resolve these cases. But what we've seen in the practice is that there are extreme positions on both ends that have nothing to do with the real values involved in these infractions. Everything is out of proportion to levels where, frankly, it looks like an extortion based on the work done by the infractor themselves and the values that they're placing on these brands, that due to a lack of provision, sometimes negligence, sometimes, frankly, intentional, they've reached a situation where the sentences can be very large against companies with a great patrimony. How does the system work in the case of companies that have a small dimension from an economic perspective, or that operate informally? It's absolutely inefficient, and so nothing gets achieved, which leads us again to the point where I completely agree that we have to find the most efficient means for the reestablishment of damages and prejudice of intellectual property. But when it comes to the damaging the companies, I think it's excessive, and at least in the Mexican experience, I might say that imposing fixed rates has led us to this point. What's next? I think tools like brand evaluation, and so I think this opens a landscape for us to evaluate damages more precisely and achieve fair indemnizations. Otherwise, we are assuming, we're not even reflecting on the capacity that this system has to truly remediate infractions. Thank you. I think we have a moment for discussion and maybe answer some questions. So congratulations to our panelists. Excellent presentations. My question has to do with the punitive damages. I don't know if I quite understood what Mauricio commented, but I still have doubts as to whether in Mexico this exists. I would like to mention the case of Paraguay. Our authors' rights laws, among the options or alternatives for compensation or indemnization, talks about the value of the non-contracted license plus a 100%, which in some cases was established at 800 to 900%. And so, in the case, I don't know if Mexico or the Andean community, if there's a law like this one, in the case that it's not established, would it be viable to see claims due to punitive damages? Now, today we have this formula which has been understood as punitive in the sense that it's not necessarily proportional to the damage caused, but it's a way to punish it. And now we begin to see it permeate other legal areas and civil matters. There's an interesting jurisprudence by the court in a case in which there's a claim of moral damages due to the death of a minor in a very well-known hotel in Acapulco, where due to carelessness and electrical cables, a 12-year-old child was electrocuted. And the court says the indemnization or the compensation for a death is simply an alternative formula that the right finds to attenuate the pain of the family, but to set an important precedent, we apply a mechanism of punitive damages and multiply it by 4. So that's a precedent that is being cited in all cases of this nature to start to build a criteria of punitive damages, which later on I believe will be more formalized in the law. Let's imagine that this is what should be paid by the infractor to the owner, and so in your opinion there's an excess in the payment, and there are many cases where it would actually be less than expected. Now in these cases, is it preferable to have some excess that can be corrected than otherwise? Because you mentioned an accident, but in Peru the system of civil responsibility is an enormous failure, because if the person who runs someone over will pay $2,000 or so, no one is meeting or fulfilling those responsibilities. If there were $1 million compensations, those behaviors might be corrected. And so it's true that sometimes there's excess, but I think that excess would have to be corrected with the right authorities. But I think it's better sometimes to have that excess than a lack of these activities, because this will just lead to impunity and a lack of compliance with the laws. In addition, it has a purpose of dissuading. It's one thing to compensate, and it's another thing to say, I don't want you to do it again, and I don't want anyone else to do it again. And so there's a dissuasion involved, and so it has to be increased. There has to be a reasonability, of course. If Carlos writes a book and I pirate it and sell 100 units, it would be ridiculous for me to charge 1,000 million pesos. But in any scenario, it's better to be a little bit excessive than to not punish enough. The truth is, I agree with you. It's better than impunity. But I do believe, again, we embrace this idea of punitive damage. It's in our laws for decades, and we haven't modified it at all. And I think today we have the instruments from a process perspective and the judicial perspective that's different from what it was 30 years ago. And today we could better adjust things in order to seek more realistic rates. Obviously trying to remediate the damage, but calculating more accurately, and this is all in a fixed rate. And while we look at the right percentages, in certain cases it's about the values added by the infractor to the case. That is what's used for the quantification, leading us to exorbitant values and punishing
large companies. We could deliberate here that there were more elements from a subjective perspective to have stopped from incurring in infractions on a smaller company. I wanted to add an anecdote. When you look at the treaty signed with the United States and Colombia, where we see pre-established indemnizations, there's a specific mention where it says that under no circumstance these damages will be understood as a sanction. This has led to a set of discussions in Colombia on whether or not what's in the statutes do not match what would actually be an indemnization in a traditional system of civil responsibility. This generates the existence of a sentence. I think it's all a fiction, which includes the damages caused to the owner of the right, and that fiction generates an integral reparation. And in this case, in the Colombian case, for example, there would not be a sentence per se. But when we go and we have a look at what is in the TMC signed with Mexico, in the case of Colombia, we find that this statute should serve as a dissuasion. And so this is where we'll be told, yes, since it says dissuasion, it means it's punitive. But we could still interpret, if you extract all of the benefits of the infraction, in reality, you're generating a dissuasion of the infraction. Now, the problem may be in that when we only indemnize the damage and the infractor obtains benefits from it after reparations, there's an incentive to continue committing it, and perhaps the damage, when they're able to extract those benefits or through a traditional system of responsibility that allows us to remove those benefits from the infractor, then we could reach the conclusion that we are dissuading the infraction, or that we are removing incentives to continue producing that infraction. Questions? José Roberto? Colombia, well, first of all, thanks to everyone for this great presentation on a subject which I think there's a lot to talk about. And Colombia is still pending to regulate the pre-established indemnizations, but I wanted to ask Mauricio what advice you might have. What would be the criteria for this? Sometimes it's difficult, but in my personal case on this subject, it can be very complicated, and I would rather not have them. But right now we're using the old criteria. I'm in favor of the pre-established indemnizations, margin of minimum and maximum amounts for the judge to have certain maneuverability, because it's one thing to sell pirated books and software. The profits are different. And regarding independence of responsibilities, I think the interpretation that we have to do goes like this. Like on many other subjects in authors' rights, there are civil responsibilities and administrative responsibilities. Basically, you've done this, and so you don't go to prison. You pay the penalty and compensate. We can't just say, no, you have 3 different responsibilities, you've gone through all of them, and you have to assume those responsibilities. Now, in reality, I think, in our experience, I would recommend, or I would think that it is necessary to carry out some specific valuation, maybe have a look at some specific cases that have taken place in other countries, in order to really know where our issues are. I think it's an exaggerated percentage, and it leaves no movement for us. It has to be applied in a radical fashion, and that's what leads us to these extraordinary numbers, which I think absolutely distort cases. We have a minute in case there's another question. Of course, the possibility here is to just not commit the infraction, right? That way you don't have to pay for it. Now, it's difficult to know if you're committing an infraction or not, what point you're at. And in author's rights, the same thing applies. It's a bit of a gray area. I wanted to ask Dr. Mauricio what your opinion is on the path to be taken, the recent reform to industrial property regarding the responsibility of the administrative authority being the one to take charge of the imposition or the taxation of damages beyond constitutionality or not, with regards to the criteria that we've sustained so far. Then we'll have to wait for the first cases, but if we can make a forecast, I think the INPI will have to learn and acquire skills of a judicial character in order to enter a field which has not been its usual competence. And so with the right instruments, and if we're open to receiving information and applying these criteria of legitimate value to establish the values of an infraction for compensation, then I think we could get to a more balanced system. That would be my expectation. Another question? No, we're done. One last question. Congratulations again to our speakers for their presentations today. Now, for this question, I just want to highlight the Ecuadorian experience. The law that currently impacts intellectual property in Ecuador proposes a legal figure which is the possibility for the administrative authority to dispose of a certain economic compensations when there are infractions committed by the public sector. This is to say, they're given the possibility to redirect their actions, paying a compensation through this position of an administrative authority. I'd like to ask the panelists what opinions you have when we speak of this figure of pre-established indemnizations and how it may be an administrative authority which can fix this sort of compensation, given that it's already somewhat the scope of what a compensation might be, could be. In the case of Colombia, although the National Direction of Authors' Rights is able to direct conflicts between private parties, this can be done not as an administrative authority, but around a principle in the Constitution of 1991, in Article 116, which is understood in harmony with that of collaboration among the powers, which allows them to assign a jurisdictional function to administrative entities. And so in the case of the national management of authors' rights, it's not an administrative function, it's a jurisdictional function. And in this sense, what exists there within the national direction is a jury, and the traditional laws of competition, the general code of the process, that we have the Tribunal of Bogotá, which would be the competency of a circuit judge of Bogotá, and this is how it works in Colombia. On an administrative level, curiously, the National Direction of Authors' Rights does not have sanctionatory functions outside of collective management. In other words, it can only exert it against associations of collective management. It's all based on the subjects, and so it could not administratively decide it in cases of infractions. This is just to give you the Colombian reference. I think what we should seek is like another general principle for the equal treatment among the public and private sectors. This is to say the private infractors should be treated the same way as public ones, and the public the same as private. That should be the rule. Very well. I'd like to thank Dr. Hugo Gómez, Carlos Andrés, and Mauricio for these extraordinary presentations today, and all of you for being with us. Now we invite you to continue with lunch. Thank you.